Clement never said anything about the lawyers who talked about the defense. The defense has said as follows: we're trying to win at all costs. We only care about winning, not just.
Didn't I sustain that objection?
No, you did not until the fourth time I asked it, Your Honor. I objected 4 times. Let me continue. We suborned perjury, stated 3 times. I objected each time. We could have called the worst of them all. We could have called Haji. The court knows we found out about him that morning. The court made a finding that their discovery violation was not inadvertent. That means it was intentional. That means it was not accidental. They got up here and just told this jury that they didn't hear from this witness Haji, that we could have called him. The court knows we have a hearing about it. It's been very clear. The court found that they were not honest in what they provided. They were not honest about when they actually turned the information over. And now he's up here and able to argue that. And when I object, basically I'm told it's overruled. I'm the judge. The problem is the court made these findings. The court said we could not disparage lawyers. Let's be clear. If anything that he had said was true, that we suborned perjury, that we don't care about justice, those are reportable issues to the state bar. The court knows it's not true. I know he knows it's not true, Your Honor. I assume he knows it's not true. And then finally, he has repeatedly misstated the standard of reasonable doubt. There is no standard whatsoever where you can say that each one of these are, quote, reasonable doubts. That is not a correct standard. The standard is looking at all the evidence in total. Did the people prove the case beyond a reasonable doubt? It is improper to say, if this fact is wrong, that is, quote, a reasonable doubt. You can argue that that evidence is important enough, etc. So they're misstating the reasonable doubt. But more than that, Your Honor, they're disobeying the court's order about disparaging other lawyers. I object. The court lets it go. Then
No, wait a minute. I don't let it go. If I see or I think that Mr. Tacopina is disparaging you or you are disparaging him, I will put a stop to it.
Judge, I objected 4 times. You overruled all my objections. You finally sustained an objection. And when the court sustained the objection, I made clear that my issue was the second part of it, which had to do with they were, in essence, disparaging both of us. Your Honor, I mean, it's not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on. Kathy, was that said?
I don't remember.
Your Honor, we said
All right.
3 different times.
If it was said, then I should have stopped it. But I don't remember if it was said. You have made so far 9 objections. 6 were overruled. 3 were sustained.
The problem was,
Therefore, what?
The problem was, I believe the first 5 I made were all overruled. The court, Your Honor, I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are. I'm not going to sit here and tell the court that I'm objecting when he didn't say it. He said repeatedly we suborned perjury. Your Honor, that statement in and of itself is severe misconduct.
All right. Can you, in the break, can you look? Can you say? If that was said, then I'll bring it to the attention of the jury that that's an improper statement.
This is what I'm asking. Mr. Tacopina can go after our witness all he wants. He can even misstate the evidence. What he cannot do is he cannot argue, A, why we put a witness up there. He cannot say that we suborned perjury. He cannot say that all we care about is winning. He cannot say that this is supposed to be the pursuit of justice and the prosecution doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care. And Your Honor, the court's already found, and the worst of them, and I want the court to instruct, he got up there and argued, why didn't you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Well, will the court do something about it? Will the court instruct that that was improper?
Rocky are married.
Can I respond?
No. Failure to call logical witnesses is permissible. You're going to have a rebuttal argument. You can address it in your rebuttal argument as to why you didn't call it.
Your Honor, this is all I'm asking, Your Honor, and I'll say it. The court knows what happened. We've had many hearings on this, etc. They hid the evidence, they presented it late, they had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. And when he's standing up saying, well, that's not his statement,
The judge has disagreed with you on this. Why are you arguing on this?
So yeah, Your Honor, I can go back and I can go and argue in the court and say, well, it's just both sides are arguing. But Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply with discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Non-inadvertent, Your Honor, means they lied and they intentionally did not give us what they
I don't
were
agree
supposed
with
to.
that. That's not, doesn't mean he lied.
Your Honor, non-inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent. I'm not going to debate with you whether they were or were not lying. I don't believe it was a lie. I want to give the court reporter a break, and we'll take a break until 3. Wait.
I have to just respond to a few things, just a few things, but there's a record here. One thing, I don't want to upset the court, so we can do it.
You're not going to upset me.
No, I'll be quick. I don't want to give her a break, I'm sorry. But there were some things that were said that were just wrong. First of all, they called our witnesses liars in their citation. So I'm calling their witnesses a liar, which he admitted to be, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously, they're saying we came up with this Tottenham story. So they're saying, I object, as they say I'm supporting her. That's what they're saying, number one. Number two, I can't say that they want to win at all costs. That's not argument. I can't say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that wasn't a statement. I said it's not a sworn statement of 12B, and it's not a recorded statement. I said it's a summary. I'm accurate in describing it. It is a summary. I'm just going through what I said. They disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him when he didn't interrupt you?
And the thing that he said, though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. If the jury finds he's incredible on one thing of importance, like the shell casings, that's a reasonable doubt. If they so choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. They can say, no, it's not a reasonable doubt. But I can make that
It's fair
argument.
comment.
I know. But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said he has an issue with it, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lululemon. I said, if Lululemon was inconsistent with Haji, we would have heard the tape. I didn't say they could have called Haji. If I can show you where I said that, I would never have said that. We could have called Haji. He wasn't willing to come. So I never said that. I just simply said what was on the record.
Right. And if it was said, Mr. Lewin can address it tomorrow. If it wasn't said, then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find...
That was a bit exhausting. We'll get caught up to real time here. Actually, do you guys want to go back to... Let's go back to Law and Crime, because I think there's synchronization with the audio captions was a little bit better. Get the captions up here. Guys, I don't know, that was draining. That was draining. And there were a few times throughout this trial where Lewin would make these arguments and say that the defense just said something that they didn't actually say, and it'd be very hyperbolic in terms of the paraphrase, right? I understand when you're trying to recite something without the court record, you might not get it word for word correct, but when you drastically change the meaning of what's being said and you do it over and over, you lose your integrity levels knocked down. So, yeah. So, let's see. Yeah, like dealing with the toddler. No, Taco, keep it going. Taco says I stopped smoking years ago, but now I need a smoke. No, no, no. Tacos instead. Just get some tacos. Shout out to Peter Ortiz. Peter Ortiz says Turtle Man wants to fight. I mean, like, the back of his head, like, does give me that. And we saw this during the defense's closing statements so far. After Lewin would object and the judge was like, overruled, and hushed him up, didn't want to keep it going, Lewin would keep, like, craning his neck like a turtle, like, trying to make eye contact with the judge, like, come on, come on. So Turtle is a great comparison. Speak of Peter, Peter has given 10 gifted memberships in the chat. When the court's going, I do try to just let it go without being a Pawsey McPawserton. I already saw so many of you in the chat saying thanks to Peter for doing this, but if you missed it, drop some booms in the chat. Some boom, 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 whatever is here for Peter Ortiz. Peter, big appreciation here, gifting the 10 memberships. I need to start counting the gifts in the, let's see. We've got a boop counter, we've got a squeak counter, and we'll get the gift counter going. We'll get Peter in there. And I was thrilled earlier. We got a little boop out of Takapina. He said they could have done that. They could have been like, boop. And I don't know. I would love to see if, and I'll ask Mel, you know, if Mel goes live on YouTube and does a recap tonight. She's in the courtroom right now. If I get a chance to ask her, like, I mean, I think she's in the courtroom when this is going on, but have there been times where you've been, like, outside the doors, but you're able to hear stuff going on in the courtroom? Because that was very elevated in volume. That was yelling. That was yelling. And we've got an hour and a half left today. So I don't know if we're going to get to Lewin's start of his rebuttal closing. But if we do, and he is amped up, I don't think that's going to be a good look at all, because Takapina has primed the jury to pay attention to that. He's taken some jabs at the way that Lewin, specifically, not so much Mr. P, has approached and yelled at witnesses. Like, just crazy. It'd be one thing if it only happened one time, people lose their cool. Sometimes it's totally justified, it happens, we're human. But this seems like it's a strategy all the time. How do you manage in a courtroom like this? Like, it reminds me of Brian Steele saying, I used to love coming to work every day. But he got tired of dealing with Adrian Love specifically. That's how I would feel if I had to work in the courtroom with John Lewin. Even if I was on his team. So, but yeah. Just holy moly. Dat Pod is in here joining us late. You just missed the almost one-way squabble. Almost the one-way squabble. It has been a time. So, also going back to this, I don't know. So, I don't think I've said anything about Rihanna and Rocky being married. I don't think they're married. I've never actually seen anything to suggest they're married. So, thanks for the question, and I guess it's an opportunity to say it out loud. But if you're looking for marriage paperwork for Rihanna and Rocky, I'm going to guess that there isn't any. Because they're not... I've never seen that they're married. But also, is Rocky worth $30 million? So, I mean, the figures coming up online are saying he's not quite worth $30 million, which is a bit surprising to me. But yeah, when you bring up a lawsuit against somebody and you're suing for damages, the damage amount that you claim doesn't necessarily need to be less than somebody's net worth. Especially, you can also go after assets, but it's really not a... Like, if I'm only worth $3 and you feel like I did something and you want to sue me for more than that, I caused this much harm to you, the amount you're looking for can exceed my net worth. It's not, there's no restriction based on that. Additionally, a jury can award damages, whether it's punitive or that are above the amount. Really, the biggest cap would be statutory limits. And I don't know, does California have a punitive damage cap? I know New York doesn't. Virginia does. I learned that through Depp trial. Punitive damages limit. Okay, so this is just a quick pull from Silva injury law, that in California there's no specific limit on punitive damages. However, courts generally, so as a matter of practice, award punitive damages in an amount that does not exceed 9 times the total amount of compensatory damages. So there you go. There's some constraints through the appeals court there. Get back over here. But great question. And again, if you guys are hearing us talk about punitive damages cap and you think about it in another trial, always look up the state that you're talking about, because there are different statutory limits or maybe no hard limit at all. Chloe Albert's Revenge says, years back, a dude here in New York City had a pet tiger in his apartment. One day, Tony Claus hit him. He goes to Pennsylvania to get treated. Moral, people seek medical care out of state because they are hiding something. Yeah, that might be. And I think that's interesting too, because like if police were to go look for stuff, they might not look out of their jurisdiction, especially not out of state. So another good point there. Speaking of Relly going to a New York hospital for these knuckle scrapes. Again, because he needed to for the nature of this case. They're starting to file back in. I'm interested in seeing how this starts off. Are we going to get like an objection within the first minute of them going back into it? Peter Ortiz says road rash is the cause of the knuckle scrapes. I mean, it's so highly probable he does fall down to the pavement in the video. I don't think they're saying anything interesting, but I am trying to listen.
Yeah, right there. You gotta come around there. Okay. The tuna goes back and make it. Okay. If the tuna goes back and make it. No.
Danny says that Rihanna said in an interview that Rocky had to take care of his legal issues before marriage. Smart. Especially in California. California is a shared debt state. Alright, I think the bailiff is saying everybody's here. Yeah, Peter, this had me laughing. But Judge, he's not playing fair. I need my pacifier. It's just crazy.
All right, let's go on the record. We're outside the presence of the jury.
Outside the presence of the jury.
Yes.
Are we still on a break?
I asked Kathy, the court reporter, to check her notes, and she's able to do that. And there is a indirect reference, and it's not even clear, to really and embracing perjury. So far, Kathy has not found the word suborn. Embracing perjury, I don't even know what that means. But
Braced really as a witness.
from here on
I
out,
remember.
from here on out, if any counsel wants to state that a witness committed perjury, that's fair game. But I do not want either directly or indirectly any counsel accusing the other one of suborning perjury, encouraging perjury, touching on perjury. I don't want the word counsel and perjury being used together.
Turning a blind eye?
What?
Turning a blind eye?
That would also include comments such as, we're here to do justice, and all they care about it's improper. It's not only untrue, it's improper.
Yeah, and stay away from that. They're only, they're winning at all costs. It's just, well, it's very common on the evidence.
They can say about the evidence, they cannot say the prosecution is, all they hear about is winning their case. All they don't care about justice, that there's authority that says that.
Yeah, no, that's over.
And judge,
Stay away from that.
and yet you don't believe it's true.
No, I don't. And I know it's not.
See,
All right, so stay away from what the prosecutor's motives are. Talk about the witnesses, don't talk about the prosecution's motive. And when Mr. Lewin speaks, you're not to talk about the motives of Mr. Tacopina or Mr. Siegel.
Joe, you're free to come and comment on, hey, they didn't call this witness, etc., just not that extra step.
All right,
Well, my explanation will be much shorter now.
what's that?
My explanation will be much shorter now, so.
I doubt it. Let's bring it here.